Now, at the back end of last week, the International Court of Justice heard South Africa's case for genocide instituted against Israel. South Africa wants the Middle Eastern country's conduct in Gaza declared as a genocide against Palestinian civilians, and in the meantime, a relief of provisional measures that will halt Israel's military operations. In the interim, Israel has denied allegations questioning South Africa's procedural validity and denying human rights violations. Joining us to unpack this case in greater detail is legal writer for Business Day, Tauriq Moosa. Tauriq, always a pleasure and a good afternoon to you.
Good afternoon to you viewers.
Tauriq, I think what's important to also deduce at this point, as we wait for a verdict from the ICJ, is the powers the ICJ has. Just what a kind of order can this court give in regards to our case or to the case made by South Africa against Israel?
The ICJ is the main dispute resolution forum for the United Nations. So all United Nations states go there when there's a dispute, particularly when it comes to concerns over a particular international convention. So in our case, we are disputing the notion of genocide in the Genocide Convention, to which we and Israel are signatories. So we say Israel is committing genocide, and Israel is saying they are not. That is a dispute over a particular term in a convention to which we're both signatories. The court is then provided, we've argued on Thursday, then Israel responded on Friday. What the court can then do is make a definitive decision that says this is what genocide means in general and also in this particular context. What they can then do is also so we've asked for what's known as provisional measures, which are like interim interdicts, so what you get in the meantime, which can be granted fairly quickly. So we think within a month it'll be granted. And what they can say is the court can order Israel to stop its current military operations in Gaza, which effectively means a ceasefire. It can make that order, but then there's the whole issue about enforcement. So that's the orders it can make. Whether it's enforced is a completely separate question.
I think yes, and absolutely. The issue of enforcement is an important one. And I think the reason why all of this is important in my mind, Tauriq, is also what's on trial here is the legitimacy of all of these processes. I think it's the first time that international law is put under the spotlight like this, specifically maybe for South Africans. And we are seeing many people casting doubt on the ability for enforceability, but also on the credibility of the process. I'm just keen to get your thoughts on that.
So the only way that any court, whether it's the highest court in the world, the International Court of Justice, or even a magistrate's court in Joburg, courts do not have the power of an army or a police. The only way that courts exist is through the legitimization of public trust. So those who participate in court processes have to agree that we will follow through. So in the International Court of Justice, the players and the parties there are nation states, so not individuals, so it's nation states. So primarily the way that we enforce is the fact that the ICJ exists at all. It exists because nations all agreed that we will create a forum to resolve our disputes. And the only way you participate and create such a forum is because you think it's a legitimate forum. And therefore, how it decides, how it operates, you've all agreed to that by definition. So when a state refuses to adhere to some kind of order or enforcement, that creates an issue. That then goes to the UN Security Council, and that's where you can have sanctions, etc., which can be imposed on nations that refuse to adhere to the orders. However, what can't be overlooked is when an International Court of Justice decision is ordered, it has massive diplomatic ramifications. So when you have such a massive case like this, a refusal or adherence is going to be closely monitored by the entire world and will have obviously ramifications for the particular party that refuses to adhere to it.
Another interesting part that I think has been heavily debated now that we've had both sides of the arguments here at Tauriq is really the issue of, the strength of the case against Israel, but even the case put forward by Israel. I'm keen to get your thoughts on this one as well. I think some of the things that have been questioned, for instance, is the procedural validity forced on South Africa's part here. I'm keen to get your thoughts on these rather technical terms.
So with regards to South Africa's case, a lot of international human rights scholars, in particular the experts I've spoken to, have said that we have one of the strongest cases that they've seen. And the reason that we have that strong case is that we're not asking for a definitive answer on the question of whether Israel is committing genocide. That is not actually the question. The question is there enough supporting data from sources such as the United Nations, Médecins Sans Frontières, the Red Cross, and other internationally recognized humanitarian organizations for there to be a plausible basis, which is a lower bar, that the court can infer that the acts being committed are genocidal. So it doesn't need to be whether it is genocide, it's whether the acts currently being committed are genocidal nature. So it's a much lower bar that they can then answer within hopefully the month or so. Mm-hmm. That then allows the court to preserve the status and say, no more operations, because we will then decide later down the line whether these actually are genocidal. So the case has been put forward fairly carefully. The South African's application is 84 pages with almost 600 footnotes, and most of which comes from, as I say, those sort of sources. Israel's response, of course, is that South Africa has obscured various aspects of the case, has not given the full picture of, for example, Hamas's interventions and Hamas's engagements in Gaza. For example, Israel is saying that it is actually Hamas that is killing a bunch of Palestinians, not actually Israel. So this is the issue that the court faces, that they've been presented with documentary evidence, and now have to decide which way does it actually swing. As I say, South Africa's bar is much lower, and it would be more prejudicial to Palestinians, according to international human rights law experts, for them to not grant the order, simply to stay operations, than for them to allow it to continue. Of course, Israel's case is that Hamas is not a participant in these proceedings. So if Israel is ordered to cease their operations, nothing stops Hamas from merely breaching that.
Interesting, arguments I've seen post the arguments being presented here is the question of the independence of the judges here and their ability to be independent, to act with absolute integrity, and even their allegiance possibly to Israel, to supporters of Israel. That's also been put out in the spotlight. Yeah. Tauriq, are we concerned about this at all?
So Francis Boyle, who was the first lawyer who's the United States attorney, who then became a professor of international law, I think he's now at Rutgers, was the very first person in the world to ever obtain an order about genocide from the ICJ, and that was I think in the 1980s. And according to his assessment, one of the concerns he had when he was doing these cases in the ICJ was precisely this, as you've articulated, this issue of independence of the judiciary. His concern is that the current president of the court is President Donahue, who is, to use Francis Boyle's very elaborate term, is a US-American apparatchik, and has been basically a stable US, embedded in US diplomacy for her entire career. So he doesn't think she's independent. The deputy president is from Russia, and the majority of the other countries, the majority of judges from their particular countries that they come from, have not said much about the current issue. So, for example, America has lambasted South Africa's case and said there's no basis, it's baseless, and so on. So if we're going to impute the particular countries to their judges, there's obviously a concern. Mm-hmm. And other political scientists like Norman Finkelstein have also said that they're not convinced that the judges will be independent. It's very difficult to assess how it's going to be ruled, because anything can influence the judges. Mm-hmm. Ideally, of course, they have to be independent because they have to provide a written judgment. So they can't just say, because Biden told me so. They have to say, in terms of this convention, this fact, etc. And we must also remember it's 17 judges, one of whom is former Deputy Chief Justice Moseneke, is also sitting on this bench as well. So it will be a very fraught dispute between all the judges, because I think there's quite a lot of politics behind the scenes that will decide this as well.
What we're also seeing here, I guess, is the issue of a precedent, and I'm keen to get your thoughts also on that. Whether we have an outcome that favors South Africa or not here, Tauriq, what precedent has been set here? And I say this because I think with geopolitical strife becoming very evident in the world, the ICJ may become a way more busy, court than it has been in the past.
Mm-hmm. It's actually interesting. The basis of South Africa's case is itself based on very recent precedent set in the Gambia versus Myanmar case, which had to do with the genocide of the Uyghurs there. And so basically all that South Africa did was take the Myanmar case and basically built it into its current, into South Africa's case against Israel. So it was actually, we were using precedent that was already set. So all we're doing is really embellishing on precedent that's already established in the court according to South Africa's case. What this will do is it will have an enormous impact, obviously, in that region. And then it will also feed into the separate case, which is the criminal case at the International Criminal Court. And there, the office of the prosecutor, they will obviously be considering both, even if we don't get our order here, it will have considered the evidence that was presented. And if it gets the order, there's a stronger case for the prosecutor to then target the higher ups, for example, at Israel. So there's going to be those kinds of ramifications as well. Furthermore, according to experts I spoke to last week, regardless of the outcome, there's going to be a massive impact on in terms of international diplomacy and international relations, because so many are becoming more vocal as a result of this. Or more countries are feeling emboldened to speak out. So you'll see, would have seen a few days ago when Germany entered its opposition. Decided to intervene in this case to oppose South Africa's case. Very quickly, Namibia, for the first time in I don't know how many decades, has spoken out against Germany. So all of this speaks to a sort of global tilt towards a sort of diplomacy and morality that we also saw, in past eras and so on. So it also has emboldened other countries, in particular in the global south, to speak out.
The world certainly is changing. Tauriq, thank you so much for this explanation. I know we'll be in touch again when we have that verdict out. Thank you for your time. Very valuable. That was legal writer for Business Day, Tauriq Moosa.